Once again, we've allotted 15 minutes per side. You want to?
I'm sorry?
Do you want to move that up so that?
I'm not sure I need to move it up or down or.
I think that might work a little better.
Okay, that'd be great. Your Honor, Scott Murphy, on behalf of the appellant Perlee Rochelle, as the personal representative of her son Clifford Jones. Here with me is Charles Barfield. What we would like to do is split between issues 1 and 2 of the brief that I'll take 6 minutes, and 3 and 4 of the brief that Mr. Barfield will take 6 minutes, thereby reserving 3 for rebuttal. May it please the Court. Your Honor, in August of 2004, after about 10 days of trial, the jury in this case delivered a verdict finding that the Department of Corrections for the state of Florida was guilty of negligence in its care and treatment of Clifford Jones during April of 1998, which led to his death, and awarded damages in an amount of $500,000 for past pain and suffering on behalf of his daughter, Carmia Lee, who was 17 years old at the time, and $2.5 million for her future loss, in addition to about $6,000 in funeral expenses. After that verdict was delivered, the appellees in this case filed a motion for new trial and in the alternative, a motion for remittitor, and that hearing was held in December of 2004, at which time the trial court, Judge Davey, determined that, in fact, he would grant a motion for remittitor or, in the alternative, a motion for new trial. That ruling, we believe, was in grievous error here. It is simply unsupported by what occurred at the trial. And really, what we have is a situation where the trial court, at the end of the case, found the verdict to be too high. Said it was excessive. That's what he says, I believe, in his surprisingly high or surprisingly excessive, to shock the judicial conscience. And in coming to that conclusion, or once he came to that conclusion, he went back and looked at the 10 days of trial to find, well, why did the jury come to this conclusion? And if I can find some reasons for that that are error, then I will have a basis to grant this. So if we start from the premise of, was $3 million in pain and suffering for Carmia Lee excessive, and find that it is not, the entire order and the basis for the trial court's ruling in this case goes out the window.
If we agree that, or if we conclude that the trial judge cannot be said to have clearly abused his discretion when he concluded that this was excessive, does that mean we have a new trial on liability and damages, or just on damages?
I missed the predicate of that, Judge. If you conclude...
If we conclude that we cannot say that the trial judge abused his discretion in his ruling regarding the excessiveness of the amount of damages, does that entitle the defendants to a new trial on both liability and damages, or just on damages?
I believe in this case it should be just on damages. I mean, the statute, I think, is quite clear.
Is that part of your argument?
Yes, sir.
Okay.
Yes, Your Honor. I mean, in terms of finding it excessive such that it shocked the conscience and granting the remittitor down to $250,000, part of that, under the statute that the legislature has enacted, is that new trial needs to be on damages only, and the statute's quite clear on that. And I don't know if the court's concerned with the exceptions that have been carved out, I believe, by districts other than this one, where you have a situation where there's a nominal compensatory award for the plaintiff, and there's a conclusion or an assumption at that point that there was a compromised verdict on liability and damages. And in that case, I believe 2 district courts have carved out this exception where they're going to say, okay, you get a new trial on liability.
That's not this case.
That is not this case. And there's not a single case like this case which would support a grant of a new trial on liability and damages in this particular situation.
Counsel, with that said, then, isn't the question that should be answered first is whether the trial court erred in ordering a new trial on damages and liability if the remitter is rejected?
Yes, and that's kind of where I was going with it, because I think fundamentally, if we take the initial premise that there should have been a new trial on damages only, now should there have been a new trial on damages only or remitted or granted? In other words, was this verdict grossly excessive to the point that it would shock the judicial conscience? Is there sufficient support or basis for that ruling? If you conclude that there is not, then the entire order goes out. And I believe at that point, this court would be required to reinstate that jury verdict and the judgment for the appellants. So I think that's sort of the natural logic of it, and I think that's what the trial court was trying to do, as opposed to concluding that the entire verdict was against the manifest weight of the evidence. When you look at Judge Davies' new trial order, he says within it, by his own statements, that there certainly was sufficient evidence, more than sufficient evidence, frankly, if you look at the record, that the Department of Corrections was negligent in Mr. Jones's care and treatment that led to his death. And Judge Davies says there was more than sufficient evidence for that, and speculates that maybe one of these errors might have had some impact on liability, which then leads to his conclusion, I need to do a new trial on liability as well. That's not the standard for a new trial on liability. I think
regarding
maybe
the
perhaps.
New trial on liability,
yes, sir.
Why wasn't it reasonable for the trial court to find that the improper comments, so they were improper, and arguments improperly influenced the jury?
Well, I think there are 2 aspects of that. One is, let's take a look first at whether the verdict was grossly excessive, or excessive to the point that it would shock the judicial conscience. Because I think unless you conclude that, then there's no reason to suspect any of these errors or things that occurred in the trial had any adverse effect on it. And I think we get into this reasonable person standard in judging the quantity of the verdict. It is simply inappropriate in a tort case like this, where you're dealing with non-economic damages, for a trial court, a trial judge, to say, I think that verdict is too high without any basis, and then further, without any further basis, to drop that verdict down, or that amount down from $3 million to $250,000. I think if you look at, for example, the Ashcroft versus...
Except Judge Davey has been around for a long time, and has seen a lot of jury trials.
Well, and
when we talk about shocking judicial conscience, we're really talking about shocking judicial conscience based on the judge's prior experiences, aren't we?
Judge, that's no way, frankly, to judge or judge a verdict. If we're going to say that one particular judge in one particular venue has the right and ability to use his personal experience in prior jury verdicts of which I'm completely unaware and may have nothing to do with this case. We have to have a system whereby in this district, just like in the 5th and the 4th and the 3rd and the 2nd, that you can look at this and say objectively, to some degree, that this is a verdict that would shock the judicial conscience.
As compared to what? As compared to other verdicts in the same jurisdiction, right?
And what is the jurisdiction? I mean, is the jurisdiction,
are we going to say, Second Judicial Circuit?
Are we going to say that the jurisdiction is the Second Judicial Circuit, so that a verdict that is perfectly fine in Dade County is not perfectly fine in Leon County? I don't think that's appropriate. I mean, because...
Why not?
Because the value of the life doesn't change. And that's why it is especially difficult to do that, and especially problematic to do that, when you're talking about a wrongful death case and a non-economic loss, meaning the loss of the support and companionship and of a father to a daughter in that particular value.
But we all know, as a matter of fact, that some jurisdictions within the state of Florida are just traditionally more conservative than others, both when it comes to damage awards in civil actions and when it comes to punishment in criminal cases.
Well, in our experience, Judge, that changes, okay, over time. And I don't know that anyone would suggest anymore that Dade County is the most liberal of jurisdictions from a standpoint of jury award. When I started, it was. It's not anymore. So that changes. But what we're talking about is a situation. No one, this is, and we gave the court some guidance as far as other verdicts that have been upheld. This is not even at the high range of a verdict for a wrongful death of a parent, to that child. I need to stop.
You're well into Mr. Barfield's time. Mr. Barfield, we'll put a couple more minutes on for you, and we'll give the appellees a couple more minutes if they feel they need it too.
Thank you, Your Honor. May it please the court. I don't know. The court gave us a 10-day deadline in order to get a transcript of the March 4th, 2004 hearing. We did all we could with the court reporter to make that happen. We did file that as soon as we got it overnight while we was here yesterday, and we did file this morning. I don't know if Your Honor's had the opportunity to observe that or get that yet, because I may refer to it.
I've not seen it. I don't know about whether my colleagues have, but I've not seen it.
Okay, we did file it. What I'm here with the two issues to address, Your Honors, is dealing with the 1983 actions in this particular case. I think that the case that's on point here is the first DCA cases, Trammell versus Bass. We did extensive writing in terms of our written position in that particular case. And in that particular case, there was a situation where there was a videotape, and there was about 6 seconds different from the version of the tape that was given to the public records. And in that, there was a material difference in terms of what the police officer version of the facts was that materially changed the outcome of that case. Now, the court held that the issue was whether or not sanctions was reasonable or adequate, and the court said that reasonableness of sanction depends on part of willfulness or bad faith of a party, while accidental or negligent destruction of evidence often justifies lesser sanctions directed toward compensating victims of intentional destruction of alternate evidence undermines the integrity of the judicial process and thus may warrant imposition of the most severe sanctions of dismissal or claim or defense, striking of pleadings or entry or default.
Counsel, how was the appellant harmed by the trial court's denial of the appellant's motion for sanctions?
It was harmed in the sense of this was a 7-year litigation at that particular time. This is the medical malpractice 1983 civil rights claim. The pre-suit mandates under the old, before the law was changed, that the parties work in good faith in order to get all the records and everything is accurate so that you can increase the opportunity for settlement. Now, in this particular case, knowing, and there was no notice, they being the Department of Corrections, that we needed that information. The reason why we need that information because the fundamental question in this case from the medical records that we got was that whether or not the medical doctor or the associate registered nurse practitioner who has the authority to transfer an inmate via a contract in an emergency or urgent situation to transfer them out or to actually admit them after the 23 hours of observation, then in 24 hours, there's a decision to either transfer them out or to admit them. Once you do that, you take on a certain duty and a certain responsibility. In this particular
Mr.
case,
Barfield, the bottom line is you got a favorable ruling on liability. I mean,
That-
you got a jury verdict on liability in your favor, so where's the harm?
well, the harm is in the 1983 action, Your Honor, because we said and we claimed that this was a deliberate indifference case. In terms of that issue, the original medical charts were destroyed in the midst of
Did
litigation.
you receive copies of the medical records?
We received copies, and the problem is that the authenticity of the copies were not genuine, and we can't believe the trustworthiness of them.
But do you have any evidence that they're not exact copies?
Well,
Yes or no, Mr. Barfield?
Well, we do in the sense that if you look at the record, they tried to produce records at trial, which is, I think, 6 or 10 new pages that the plaintiff's lawyers for 7 years never saw. And if you look at the deposition testimony, one of the nurses doing deposition, they admitted that the medical doctor as well as the nurses involved in the 1983 action had exclusive possession of those original medical charts. Furthermore, in the deposition that we did in 2001, 3 of the nurses admitted that they had looked at the original charts before preparation for the depositions. So it was during that time that we realized that there was 2 sets of medical records, one green copy, one blue copy. Similarly here, from a practical standpoint, if you look at accounting and you had 2 sets of books, it can logical and practical be, take to its natural conclusion that there's some cooking of the books. And the physical whereabouts of Dr. Kaskagan and Nurse McHugh, which is ARNP, there's a lot of evidence that they was calling in.
But nobody prohibited you from making that argument to the jury, did they?
Well, we didn't have the original records, and in order for to prove the deliberate indifference contact, if there's a genuine trustworthiness of that evidence, we know that there was 6 to 10 new pages that we never saw in 7 years of litigation. So it begs the question, are these the authentic records? Did someone who had possession of those records have something to hide? We don't know. And that's why we're home as it relates only to the 1983 claim.
You're down to under a minute, Mr. Barfield, if you want to save some time for rebuttal.
We'll reserve that.
You've got about 50 seconds left. And that's having given you the extra 2 minutes.
Good morning, Your Honors. Laura Beth Ferragasso and Ed Hudson for the appellees. Perhaps it is easiest to start with the argument that Mr. Barfield was making regarding the records. There is no doubt that the original medical records in this case were inadvertently destroyed by DOC, and that is certainly improper. The record will reflect trial counsel's explanation that although we were all working from the same copies, somehow or other at the DOC facility, they were not marked to be safeguarded, and they were destroyed in accordance with some records retention rule.
What about the argument that there were additional pages that they had never seen before that you all tried to offer at trial?
Your Honor, the record will reflect that following the hearing in which Judge Davey ordered DOC shortly before the original trial date to produce the original records, and Mr. Buchanan, DOC's trial counsel, discovered for the first time that the originals were not there, that DOC informed the court that a complete set of the records had been made on microfiche when the records were shredded. The original set of documents that both parties were working from the pre-suit period forward had been Bates numbered. when both parties got the set of records from Microfiche, same set going to each party, there were about 10 pages in the record that did not have a Bates number on them. At trial, DOC proffered those documents, authenticated them through various DOC staff members, and proffered them as additional exhibits, but Judge Davey did not allow those to be admitted. And so the plaintiff was not encumbered with any surprise documents. They certainly had them before trial to begin with, but those did not come into evidence.
But doesn't that lend credence to Mr. Barfield's argument that you were playing with two sets of books, to use the accounting analogy?
Well, I don't think so, Your Honor. There's no evidence whatsoever that the documents we had been doctored. In fact, there's not evidence of record as to what those 10 pages were, since they're not in the record.
Well, then the allegations below the documents, in fact, have been altered or doctored.
The suggestion was that Dr. Katz-Kagan, the medical doctor who attended the decedent, had perhaps backdated somehow an entry to make it appear as if she was on the scene in the infirmary rather than calling in. But as Judge Davey recognized, that argument fails for two reasons. First of all, the argument was, we don't have the original documents, so our forensic expert can't review them and render an opinion as to whether, in fact, these time entries were made at the same point in time. The argument fails because Judge Davey ruled that the forensic expert could not testify at trial because he had been disclosed as a witness too late. And so where the man wasn't going to testify anyway, the inability for him to review the records that he would testify about was immaterial.
But if we have a new trial, he's probably going to be able to testify, isn't he? So their argument becomes valid again.
And on that point, Your Honor, Judge Davey's second conclusion as to there being no harm in the failure to produce the original records comes into play, and that is that regardless of what these records might or might not have shown, the undisputed evidence of what happened, regardless of what the records said, what happened in that infirmary was certainly sufficient to overcome any claim of an Eighth Amendment cruel and unusual punishment constitutional claim. It is undisputed, for instance, that the decedent was admitted to the infirmary, he was x-rayed, he was given intramuscular and oral antibiotics, he was monitored for vital signs, additional x-rays were ordered, there was an attempt to start an IV, he was treated. Now, there may be doubt as to whether he was treated properly or negligently, but there is no doubt on the evidence presented that a 1983 action against the individual defendants could not be sustained, and directed verdict was entered in favor of the individual defendants.
Counsel, what is the Department's retention record for destroying documents?
I beg your pardon?
What is the Department's retention record for destroying documents? In other words, how long must it be retained before they're destroyed?
Judge, it's not in the record. I believe it is 5 years, but I don't.
It's not in the record?
It is not in the record, yes, sir. So from that standpoint, the entire argument about the records issue and whether Judge Davey should have sanctioned DOC in some fashion or given a Valcine instruction really becomes moot by virtue of the evidence that was presented at trial. Moving, Your Honors, to the new trial or remediature issue, Judge Webster, I think you hit the nail on the head right up front. You said, isn't this a matter in the sound discretion of the court?
But how do you get a new trial on liability as well on the facts of what happened at this trial?
Judge, I'm of course familiar with the language of 768.74, the remediature statute that says new trial on damages only. There are cases, however, and I believe counsel in the court referenced them, on additure, which falls within that same statute, where liability and damages has been ordered in the new trial. Those are typically cases of a compromise verdict, but there is also a Supreme Court case, Rollins versus Signal Construction, Florida Supreme Court 1989 case cited in both of our briefs, in which the Supreme Court permitted a new trial on both liability and damages, where the verdict indicated confusion by the jury in apportioning the percentages of liability.
That's not this case either.
And that is the only case, Your Honor, that I am familiar with where liability and damages have been ordered in a new trial in a remediature scenario. And of course, if one looks simply at the primary relief that the defendants were seeking, a new trial in its entirety, then we're again dealing with the discretion of the court and Judge Davies' findings that the cumulative effect of numerous errors and comments by counsel during the trial had an overwhelming prejudicial effect on the jury. And the Florida Supreme Court in the Stuckey case, which originated here in the first DCA, of course said that even a scenario such as we have here, where there is evidence from which a jury could find negligence, is not dispositive on whether a new trial should be ordered.
Counsel, you would agree that the statute dealing with the remediator is clear and unambiguous?
Judge, there's no question about it. The statute says what it says.
Okay. With that being said, would you agree that the trial court did, in fact, err in ordering a new trial on liability and damages if the appellant in this case rejected the remediator?
Judge, I'm not sure that I can concur with that. Certainly the statute is clear. However, there have been cases citing that statute, those that we just discussed, the Additure and then the Rollins case, which is a remediature case.
But the food lining case as well,
the food lining
case, which you
yes,
referred to
the
as well.
food lining case was an Additure case.
But this case is a remediator.
This is remediature. The Rollins case, the Florida Supreme Court, was a remediature case. And I understand, Judge, that this court looks to the plain language of the statute. However, there are these cases that interpret the statute somewhat differently.
Now, the food lining case did grant a new trial on liability as well, right?
That's correct, Your Honor. That's correct. And in fact, the food lining case dealt in some respects with some non-economic damages too, which was an aspect that counsel was concerned about. In that case, there was a defamation count, intentional infliction of emotional distress, and some damages were sought there that were non-economic in nature.
What trial errors, in your opinion in this case, that were committed by the plaintiffs or their lawyers could have had an impact on liability as opposed to damages? I concede there was a lot of stuff going on that could have affected damages. What could have affected liability, though? I mean, don't you have to, in candor, concede this was a pretty strong case for liability and negligence?
Judge, there certainly was evidence from which the jury could conclude that negligence occurred. It was a 10-day trial, and we had experts on both sides. We had fact witnesses on both sides. And so certainly, as Judge Davey recognized, the jury could have concluded and did conclude that DOC was negligent. The judge's concern, and that which I would suggest to you, is that even though that evidence was there from which a malpractice verdict could be rendered, the cumulative effect of the comments about Mr. Barfield's familial relationship with the decedent, and the plaintiff's comments to that effect as well, the almost punitive damages comments, which is per se reversible, about the budget of DOC being $57 billion, and I'm sorry, there was one other aspect of Judge Davies' order that I'm not recalling at the moment, but that the cumulative effect of these things could have swayed the jury sufficiently to err in a finding of liability as well as damages. And that is where the abuse of discretion standard comes in. Judge Davies, the one there observing the force and impact of the testimony and the improper comments and that sort of thing, and in his experience as a trial judge of many years, that was his concern, that the verdict may have been swayed as to liability as well.
Counsel, generally you file a motion for a new trial based on liability and remitted based on damages. So if the court had considered just a new trial, motion to trial based on liability, and it held that the cumulative effect of all these factors you just mentioned may have affected the jury's decision in regards to liability, then should the court have ended at that point rather than consider the remitter?
Judge, frankly, I think that would have been the proper way to go instead of giving the alternative. I think Judge Davies was persuaded that the cumulative effect warranted a new trial in toto rather than just damages, and certainly that would have been an easier and cleaner way to go. He did not do that, however. He ordered the remittiture, and DOC has not appealed or cross-appealed that aspect of it, so that's where we are on that. I believe that's all I have, and I thank you for your attention.
Any more questions? Okay, thank you. You have about, we'll give you a minute.
Be brief. I just wanted to address this situation and just perhaps it's the obvious, but going back to that Florida Supreme Court's decision in Bold versus Touchette dealing with the wrongful death issue and trial court's discretion, I think that the language in that decision is especially apropos here and is still certainly good law in determining whether a verdict is excessive. Vague expressions by the courts about, quote, conscience-shocking amounts, end quote, do not furnish the enlightenment that the public should expect from judges about how they arrive at their decisions. And it goes on to talk about that more than ordinary discretion may be allowed the jury in assessing damages for wrongful death. Judge Davies may not have been impressed by Carmia Lee's testimony, but everybody else in that courtroom was. And her loss was very dramatic and significant to her, and the jury acted well within its discretion in awarding the $3 million it awarded for her loss. Thank you.
Thank you. Thank you all. That concludes the calendar for this morning. We'll be in recess.